Welcome to 30 Years, 30 Cases series of ERA, Academy of European Law. I'm Magdalena Kycior and I'm a senior lawyer in the public law section of ERA. In this podcast, we'll address CJEU judgment of 2004 in case Omega Spielhallen C-36/02 concerning the freedom to provide services and the free movement of goods in the European Union. In this particular case, the Court of Justice ruled on the ability of fundamental rights, specifically the right to human dignity, to restrict these freedoms. This case, its context and importance will be presented today by our expert, Professor Mark Cole, who is Professor for Media and Telecommunication Law at the University of Luxembourg. He specializes in media law, covering both traditional mass media as well as the law of new information technologies. Professor Cole, it's a great pleasure to have you with us today, and I give you the floor.
Hello, everyone. I am very happy to be able to present the case of Omega. As we heard, the plaintiff's name indeed was Omega at the beginning. The case is more about laser drones, also known as laser tag games. Some also refer to it as quasar because of the technology used. It's also been tagged as laser sport, what this case is about, for very obvious reasons I will explain later. And it's also related to what others might know as paintball or gotcha. So basically about an activity in which a laser is used in a quote-unquote game to have a certain activity, which I will detail in a moment. You would not have found me in the year 2004 when this case was decided in any such activity, in a hall, in a laser drone where this game is played, because it's not actually my piece of cake. But I'm not looking at this case for personal joy or reasons, or I'm not going to look at it from a perspective of protection of minors, which actually is also concerned with this case. Why? Because in these games, the idea was that players could, with these laser guns, shoot at each other. So basically simulate killing. But I'm not going to look at the case on whether or not protection of minors would allow for a prohibition of such games. I'm purely going to look at it from a European Union law perspective. And therefore, actually, back in those days, I had to do a deep dive into the case because it is one of the core CJEU judgments over the past 30 years. I used it a lot in teaching of my students, but also in a lot of research activity. As you will see, it's a very worthwhile case to look at. I'm happy it was selected for the series of 30 years of ERA and 30 CJEU cases, and I'm even more happy that I was the one selected to present it. It's a case that is dealing with primary law, as we just heard, with the fundamental freedoms, with different fundamental freedoms, which already makes it very interesting from the perspective of EU law, but even more so because of the relationship between fundamental freedoms and fundamental rights. And within fundamental rights, the most important one we might have, the right to protection of human dignity. What were the facts of the case? Omega, the plaintiff, set up a, let's call it more neutral, an action hall in the city of Bonn, formerly the capital city of Germany, before that was transferred back to Berlin. And the idea in that activity hall was that you could play a game once you paid an entrance fee, where you would get an instrument which looks like a gun. It's not a real gun, obviously, a gun as a shape, and it has a laser technology attached to it with which you can aim at things. And if the other side where you aim at has a recipient which reacts to the laser signal, the laser beam, then your machine, your instrument would register that you did a hit. And the question was whether these aims that you would fire at would only be somewhere in the hall, attached, for example, to a tunnel or to a rock, or whether they're also attached to the vests that the other players would wear. Because then the aim would be you try and shoot the other players, because then you get points for hitting them, or more technically spoken, for the laser beam to actually reach its target. And in doing that, the company Omega used technology by a company from the United Kingdom called Pulsar. And the technology they used was actually bought and imported from that company. So there was a cross-border element from the UK to Germany. But later, after a few years of activity, they actually also entered into a franchise agreement with Pulsar Technology, according to which they basically used the know-how from this company on applying it to their own action hall, to their own laser drone. And that's important because obviously that shifted then the attention from the question of only a question of free movement of goods to freedom to provide services. In September 1994, the local police authorities, so the Ordnungsbehörden in German, issued a prohibition order. There was a pre-development before that order, but that's not important here. But eventually there was a prohibition order, and I will quote, the prohibition order forbade Omega for facilitating or allowing in its establishment games with the object of firing on human targets using a laser beam or other technical devices such as infrared, for example, thereby by recording shots hitting their targets, quote, in the quote now, playing at killing people, end of quote, on pain of Deutschmarks 10,000, which would be today about the equivalent of 5,000 euro, for each game played in breach of the order. In other words, if I may formulate it myself, you, Omega, are not allowed to have that activity ongoing if people within that game hall shoot at each other. The aim is killing people for fun by firing at them with the laser gun. Obviously, just to make that clear, there was no injury. The laser itself cannot cause any injury to the other players. But the question was, are we simulating as if you're trying to shoot other people? And if you shoot them, you get a very high score. So that was prohibited. As you can imagine, Omega was not very happy with this prohibition. And the arguments that were brought forward by the city of Bonn, the Ordnungspolizei, was it is simulated homicide, and it leads to trivialization of violence. And those two reasons are against public order. There's a danger for public order, and that's why it is prohibited. Omega didn't like that. It initiated administrative procedures unsuccessfully. It went to administrative court, again, unsuccessfully. All instances confirmed the prohibition order and said, no, there is no exception that is possible. It finally ended at the highest administrative court in Germany, the Bundesverwaltungsgericht, the Federal Administrative Court. And therefore, the first time, the plaintiffs also argued with a view to community law, as it was called then, European Community Law, with the argument, we are using as a franchise company the services provided by Pulsar, that's a British company, therefore we have a cross-border element, and that's why the German prohibition order violates EU, as we would say today, law. They also pointed out that they're using the equipment, as we heard from Pulsar, which gives this additional feeling of it may also be a violation of the free movement of goods. And they also argued that Pulsar was offering exactly the same type of activity since many years in the United Kingdom. And it wasn't prohibited there. Nobody made a point about possible violation of human dignity. And therefore, it is already, so to speak, in the community single market, and it should also be allowed in Germany. It is important that the prohibition order was based, these two arguments that I mentioned, based on the protection of human dignity as part of public order, basically claiming a killing game violates the idea, the notion of human dignity as it stands in Germany. And the Bundesverwaltungsgericht, the Federal Administrative Court, didn't question that. They said the lower courts were exactly right in finding this conclusion. But the big question is, can German human dignity arguments strike down a potential infringement of the free movement of goods and the freedom to provide services? So what were the findings of the Court of Justice? First of all, this happened in 2004 at a time when there was already a much more advanced knowledge in national judges that sometimes if you deal with a question which seems to be purely internal matter, there is still a link to EU law. And if there is, and if you're a last instance court, you better make sure that you ask the Court of Justice in a preliminary reference ruling for an answer for the question of compatibility with EU law, because otherwise your member state is in violation of EU law. But I'm pointing that out because it was the Federal Administrative Court that brought up the question to the Court of Justice. In a way, it is a quite obvious issue because we have a UK company, a German company providing an activity, but using services from this UK company. So maybe in the year 2022, in which we are now, already the first or second instance court would have actually asked the Court of Justice in a preliminary reference, what's your position on compatibility with EU law? Back in those days, it was very often only the last instance court that clarified that, which also means there were 10 years between the beginning of the activity of Omega in Bonn and the prohibition order and the final decision of the Court of Justice, and another 2 years until then the final decision of the Federal Administrative Court based on that. What's the most important finding? Well, it's about fundamental freedoms. The case is about fundamental freedoms, and yes, the court acknowledges, as had already done Advocate General Stix-Hackel, the question is about services and goods. So what does the Court of Justice do if two fundamental freedoms are potentially infringed by a specific case or specific circumstances? Well, the Court of Justice doesn't want to check both and says there is no need to check both fundamental freedoms. We have to decide which is the one that is at the heart of the matter, which is the one where there is the center of activity. And here the court argued it is services. Why? Because there is no general ban on the import of play guns with lasers, but only the ban is for the goods if they are used in connection with that specific game, and that specific game or that specific activity was to set up a laser drone in which people use those goods in order to shoot at each other for the playful simulation of killing each other. So the actual focus was on the franchise and using the services. So the rest of the examination of the Court of Justice took place only under the chapter on freedom of services. Now, remember that the chapter on freedom of services is not very extensive in the Treaty on the Functioning of the European Union, but there is actually an article, Article 63 of the TFEU, which in those days was Article 55 of the TEC, the Treaty on the European Communities, and that refers back into the chapter on the freedom of establishment and declares that certain rules from the chapter of freedom of establishment are also applicable in the subsidiary chapter of freedom to provide services. So just for those of you that read up the case or that hear the numbers that I'm using, don't be irritated that I'm talking about articles that are in the freedom of establishment chapter. That is because we have this cross-reference in freedom to provide services. The court didn't even discuss very much, is this a service? What are the elements of services? What are its criteria? It just said straightforward, this is clearly a service, that is in line. So the real question is, if it's a matter of services, if there has been a potential infringement, is there a justification for the restriction to provide these services? And certainly there is a restriction because Omega cannot do the same thing that Pulsar is doing in the UK. The Bundesverwaltungsgericht was quite careful in posing the question. The question is very simple, just one straightforward question, but it argued and said, well, we've learned from EU law, from the Court of Justice previous jurisprudence, that measures by member states that restrict the freedoms have to be applied without distinction according to nationality. They have to be applied in light of overriding reasons of public interest. And the measures have to be capable of achieving the intended aim. And at the same time, they should not go beyond what is necessary. So that basically was what the Bundesverwaltungsgericht said. That's how we understand it. But we see a problem. The question is, can we apply a overriding reason of public interest, which is formed by the German context, so the German human dignity approach, which may be different than from other member states? Or do we have to follow some form of overarching EU standard, which has to be fulfilled in this case. So that's basically the core of the question. I'm mentioning that the Bundesverwaltungsgericht asked very precisely, or referred in its argumentation of the question quite precisely to these 3 steps, because the Court of Justice, interestingly enough, did it much shorter. What did it do? It said, well, in Article 52, we have a provision in today's reference back, which says that measures can be taken by member states, even though there is a general prohibition on restrictions, if they have been taken for the aim of public policy, public security, or public health. So any measures that are aimed at reaching these goals are already possible by written justification in the treaty. So we might not even need the argument of overriding reasons of public interest, which may also be, as you all know, from the fundamental free movement of goods. The court also developed, besides the written exceptions or justifications, also unwritten overriding reasons of public interest. The court went on and said, very clearly, there is absolutely no nationality consideration in the German prohibition order, obviously, because it just said this activity is prohibited. It doesn't matter whether Omega is a German company. If they want to do this in Bonn on German territory, it's not possible because it violates the idea of human dignity in Germany. And the court even said, well, actually, that's not important because Article 46, as it was then, now 52, is a general exception, and therefore we don't even need to check that question of was there a nationality consideration or not, because even if there had been, it would still be okay, as long as the measures really are aiming at public policy, public security, or public health. So the real interest is, do we have a justified measure in light of public policy? And there the court does say something which is reiterated over and over again in the last 2 decades, and it said, such aims have to be interpreted as strictly as possible, or very strictly, because it is already an exception to the principle that you should have the freedom to establish yourself or the freedom to provide services, as in this case. So only if there is, quote, a genuine and sufficiently serious threat to a fundamental interest, end of quote, of a society, only then really this exception can carry. That sounds as if it's relatively marginal, the reasons that member states can bring forward for such measures. But actually not, because if you continue to read that paragraph of the decision, the court also says, well, there must be a margin of discretion, and it actually uses exactly that expression, margin of discretion, for national authorities in deciding whether a public policy aim is of a genuine and sufficiently serious threat. So there is a sufficient reason, sufficiently important reason. Why does that have to be there? Because the question of this approach on what is public policy cannot be standardized by EU law, because it may vary by region or also in time. It says in different eras, funnily enough, ERA as the abbreviation of the European Academy of Law in German, Europäische Rechtsakademie. So in different eras, there may be different approaches as to what is actually such an important element. And it's important in this case because, as you will see later, this is 2004 based on a prohibition order of the 1990s. And in 2022, things actually may look very different for this very concrete case. So what is the public policy threat here? And there, the Bundesverwaltungsgericht very clearly said, it's a potential violation of human dignity. Well, actually an actual violation of human dignity if the game takes place. So the court concerning that first refers to its previous case law in Schmidberger, another very, very important case where there was this demonstration on the Brenner motorway, and the demonstration led to the situation that lorries could not cross the Brenner. And therefore the question was, is that an unjustified restriction of the freedom, the free movement of goods, because the lorries could not pass the motorway? And therefore, the first time the court, in a very elaborate way, said, yes, but the restriction is actually a fundamental right. in that case, the right to demonstrate. And if the Austrian authorities decided that the right to demonstrate in this case is more important than the freedom to move goods, then that is okay under EU law. So we can use fundamental rights as a legitimate interest to restrict fundamental freedoms. And again, that is established case law, has been developed further from Schmiedberger onwards. There are also situations where maybe the fundamental rights do not, in a specific case, weigh out on fundamental freedoms. So it's a balancing that has to take place. So generally, fundamental rights can be a restriction, but now question, what about human dignity? And interestingly enough, remember 2004, we do not have a binding Charter of Fundamental Rights yet. Although the Charter of Fundamental Rights was written up and proclaimed in 2000, it only became binding with the entry into force of the Treaty of Lisbon in 2009. And the Court of Justice, other than the General Court, or as it was called in those days, the Court of First Instance, and other than some of the Advocate Generals, the Court of Justice avoided any reference to the Charter of Fundamental Rights. So also in this case, it didn't mention the Charter of Fundamental Rights. It said human dignity is undeniably, so very clearly, already a part of the catalogue of rights, which in those days were the community fundamental rights that had been developed case by case by the Court of Justice as so-called general principles of EC law. Human dignity is undeniably a part of that set of fundamental rights. That is quite something to say already in those days, and also astonishing because you would not immediately think that there would be very many situations or constellations where the Court of Justice can actually say something about human dignity, one of these very overarching values and rights. Today, it's a different matter, as we will see in a moment, because in the Charter of Fundamental Rights, we have an explicit mention of the human dignity at a very prominent place. In those days, the Court of Justice said fundamental rights, yes, legitimate interest. Human dignity is certainly a part of the acknowledged set of human rights that exist in Europe. But then the question is, what about necessity? Is human dignity per se justification for any measure, even a total prohibition of a game, just because human dignity exists? And there, the question is, are there less restrictive means? And the Court of Justice explicitly said, the conception of human dignity has not been unified. So it does not mean that the conception on how to protect human dignity has to be shared by all member states. If the Brits think that their people can have an activity where they shoot at each other in a playful manner with laser guns without damaging human dignity, that's okay. If the German state has the opinion, in that case expressed through the Prohibition order, the opinion that such games do damage human dignity, it's also okay. There is not a unified approach. Actually, in the area of lottery and games, rules that the Court of Justice had to do a lot in the past 2 decades, this idea of coherence of the rules to protect as in a certain aim has only always been applied within a member state. Coherence does not mean because the French do it in this way, all the others have to do it as well in that way. So the Germans can do it differently than the UK. And with that, the case was over. The Court of Justice said it's absolutely okay that the Germans interpret human dignity in a way that it is not okay for playful means to shoot at other people and aim or simulate the killing of other persons. So what do we learn from this very, very fundamental case? One, it's a very short judgment. Actually, it's only roughly 8 pages. If you take the introduction and the end away, it's about 7 pages, but very, very clearly argued and very, very important, well beyond that one case. Human dignity, as we know from that case, but also from the development since, is one of the core, if not the core fundamental right. And I would go a bit further and also say fundamental value that we have within Europe, at least the Europe that we're talking about when we talk about the European Union. I don't mean to say that the UK did not have the idea of protecting human dignity just because they allowed the game, but what we learn from the case beyond whether or not a laser tag game can violate human dignity is that human dignity has this overarching relevance. For Germany, this was absolutely clear. Why? Well, in Germany, as many of you will know, the basic law, the Grundgesetz, so the constitution of Germany, which has not the name constitution, but basic law, was passed after the Second World War and in view of what had happened under the Nazi regime. And therefore, on place number 1 in Article 1, human dignity is protected. And it is protected with a wording where it is clear that human dignity is inviolable. You are not allowed to in any way infringe with human dignity, which also means the German fundamental right of human dignity is very different to all the other fundamental rights, because if there is an infringement of the fundamental right of human dignity, it is automatically a violation. There is no balancing. You cannot say, well, but freedom of expression allows that, for example, in a satire, I hurt somebody else's human dignity. It's not possible. So the threshold to reach human dignity is very high, but once you step over it, it automatically means any infringement of the human dignity, whether by the state or by others, is a violation of the human dignity. Why by others? Because Article 1 of the German Constitution goes even a step further and says it is the duty to not only respect human dignity by the state, but also to protect any violation of human dignity. So, for example, just to give you one comparable case, there was a big discussion whether persons of short stature, I'm purposely not saying the way it was quoted in those days, dwarfs, whether the throwing of persons of short stature as a kind of a game, at a target, whether or not that was a violation of human dignity. It's a very famous case under German administrative law, the Zwergenweitwurf-Entscheidung. And that, for example, would also be something, even if the person that is involved in that game says, it's okay for me, I don't feel hurt in my human dignity personally, there is a dimension which goes beyond, and that's the abstract value of human dignity. That human dignity as a part of societal value order can be violated if people, for the sake of making fun, throw other people through the air, or for that matter, shoot at each other, even in a simulated way with laser guns. So that's the reason, the background, why you have to understand that in Germany, human dignity has a very high level of protection. Protection is basically absolute. And interestingly enough, if you now read the Charter of Fundamental Rights of the European Union, you will find exactly that formulation there as well. While there's historical reasons maybe for that, those of you that have already looked into the Charter of Fundamental Rights might remember that the president of the convention that prepared the text was actually the former president of the German Federal Constitutional Court, and therefore said, well, the German Constitution has the perfect formulation for human dignity. Should we not also integrate that into the Charter of Fundamental Rights? At the end, it came in that formulation. And that means our overarching, most important individual fundamental right in Europe, you can argue, is human dignity. And in that way, the Court of Justice in 2004 had a very strong foresight by saying, we accept this. And we also accept that apart from it being valid everywhere, there may be differences in national approaches, because again, the Charter of Fundamental Rights doesn't harmonize this, doesn't unify this. We still have different approaches. What else do we learn? A few more small points. It can go as far as that the interpretation of a fundamental right is part of national identity. I would argue that if the Court of Justice in that case had not allowed Germany to uphold this prohibition order, you could probably argue it would have been a violation of the national identity of Germany. It is so much in the DNA of Germany that the fundamental right of human dignity is inviolable, that if the Court of Justice would not have respected that difference, then possibly there would have been a real clash between the two legal systems. It's also interesting if you look at it from a media law perspective, and forgive that I will do that because I'm not only an EU law scholar, as you heard, but also I like to look at things through a media law perspective. Why? Because in those very days, a new reality television format had entered the screens, which was called Big Brother. For those of you that don't know the setup, basically a few people completely voluntarily agreed to live in a container, very close on top of each other. And every week, and it would be screened on TV, beginning only every day, maybe an hour, the highlights of what happened during the day in that little house or that little container. Then later there were also 24/7 monitorings of, or you could actually even subscribe to channels where you could watch this all the time. And every week, one of the inhabitants of this container was voted out by the viewers, and the last one that remains would win a prize, a very hefty prize. And in many member states where this new format had come to, it originated in the Netherlands, there was a discussion, also in Germany, does this violate, for the same argument as the laser tag game, does this violate human dignity? Not the human dignity of the individual inhabitants of that container, because they agreed to being there, at least if the agreement was based on an informed consent. But the idea of, do we want people to live under constant surveillance and be observed? To push it a bit further, what about if these people would have lived in chains and had to walk on all four, like dogs, and only eat from dog shit? Well, maybe then we would have had a situation that would have been one step too far. Anyway, in those days, the discussion was very vivid, but in most member states, to my knowledge, it was accepted, and also in Germany, it was not prohibited, that game. But again, it could have been the case that in Germany, it would have been treated differently than in the Netherlands. There was another case a few years later, Dynamic Medium, which actually picked up the logic of Omega in exactly the same way. It was about DVDs with content that potentially is harmful for minors. They had been labeled, again in the UK, it's funny, same constellation, they had been labeled in the UK for a certain age restriction. Somebody imported them to Germany, sold them in Germany without putting on an age restriction label under German law. Question landed at the Court of Justice. Court of Justice said, just because the UK gives a certain age restriction label for this specific film, it might be a different one if you apply for it in Germany. And that is absolutely okay, because the protection of minors, again, is something where there can be differing national approaches, as was the case for human dignity in Omega. So Dynamic Medium is a continuation, makes it more concrete. Again, a super interesting case because it touches free movement of goods, because it's the DVDs. And it also was a discussion on whether or not it falls under a KEC exemption. But that's a different story that I don't want to cover here. A last point, interestingly enough, in media law, what we always discuss is who is actually entitled to regulate the media? Because media are not only an economic activity, they are also an expression of the cultural identity of member states. And you will agree, if you travel through Europe and you switch on TVs in hotel rooms, you will see that the TV program in another member state may be quite different in what you can see, at what time you can see things. Think of nudity, violence, other things, from one member state to the other. And it's clearly excluded that in the area of culture that the European Union harmonizes, Article 167 of the TFEU. And therefore, the competence to regulate the media is in principle with the member states. When it comes to their economic dimension, we are in the single market. So there, the European Union can in principle regulate. And that same tension is also underlying under the Omega case. Is the fact that you can make money with these laser tag games, that you can offer your know-how in a franchise, more important, the economic activity, or is the potential damage to, let's call it, the cultural national identity of Germany more important? And the clear answer here is the latter. And therefore, I think we can learn the same thing also when we discuss on competence division between the EU and member states. And in that sense, Omega goes well beyond just deciding that laser drone activities can be prohibited under national law. Thank you very much.